name is Grace Rains, and today I'm joined with Meredith Lowry of Wright Lindsay Jennings, and we're going to talk a little bit about why IP matters to angel investors. So Meredith, you want to tell us a little bit about you to start off?
Sure. I am a patent attorney, partner at Wright Lindsay Jennings. I've been doing this 20 years, which seems insane, but I've been a patent attorney the entire time and focusing on patents and trademarks, usually for the product space. So people selling, also some med tech pieces too.
Yeah, awesome. Well, I'm excited to pick that 20 years of knowledge, pick your brain of 20 years of knowledge, because I feel like IP, there's a lot of confusion around it. There's a lot of misinformation. Yes. It says Pandora's box. People don't really understand. And so hopefully we can kind of get down to the basics and at least crack a little bit of the nut that is IP. So I want to start off with the basics, which is what are the different types of intellectual property, and then we can dig in deeper into each one of them.
So the different types can differ based on who you're asking. The three main ones are going to be patents, trademarks, and copyrights. Now, patent is going to focus on how something works or a composition of matter, a machine. We have designs as well that are patents, though they're kind of like this weird little hybrid of almost trademark too. But so those are there. And then we've got trademarks, which are source identifiers for a product or a business that allows that business to show this is coming from that business. And copyrights are things that protect artistic works. So it is very much the expression in that artistic work. It's not the function of the artistic work, it's just how it looks, what's being conveyed with it.
Yeah. So from an investor's perspective, how do we know which type of IP is the right IP for a startup to have?
I like to look at the industry that the startup is in. And sometimes that's a stretch goal. So if we're in the toy space, and I use Lego a lot as an example, startups aren't Lego level. But there's aspirational goals of like, how is Lego doing its branding to make its trademark work and do the things that the startup would also be wanting to accomplish with that piece of IP? Are we getting design patents for these articles? Are we getting utility patents? What kind of utility patents? And having that kind of scope there is important. I mean, like with Lego, I mean, there's, I mentioned compositions of matter or types of patents, utility patents, but we don't see that much in the Lego space because plastic is plastic. So it would be a weird sort of situation for them to go and do that. I mean, I know there's lots of different plastics, but also Lego doesn't tend to venture out of that. So that's where I usually start, and then after that, it comes down to priorities. I mean, if the startup needs to keep the lights on, sometimes maybe a trademark's not the thing to be filing right then.
And so how, in kind of the same vein, how do we know whether or not if they do have IP, that IP really gives them a competitive edge that you hope that IP is going to give you for that investment?
So looking at the individual pieces and what's going on with them is important. Some patents, especially both with design and utility, we can get very narrow protection. And it's going to go through the system because it's so narrow. There's not a lot of negotiation with the patent office. The business gets an asset, but is it then defensible? If somebody is getting all of the little pieces and little knobs of a Lego brick protected when the competitor's only going to need to do half of that, to get around it, then that patent's not really worth the money that was put into it, much less an investment.
Yeah, no, that makes a lot of sense. So I want to dig into each of the types and talk a little bit. So I want to start with patents first. So just basic, what's the difference between provisional and non-provisional?
Okay, so utility patents, the functioning kind of type of patent, that is, we can file it two different ways, provisionally or non-provisionally. Non-provisional patents are the ones that most people think about when they say, okay, patent application pending, it's going through towards examination, it will issue.
Okay.
A provisional doesn't issue. It is the foot in the door. We, like the rest of the world, are a first to file situation. So the first person that files is the one that's supposed to get the patent if it's not already going to have an issue. So we file early with those provisionals. A lot of times, we want to see startups file provisionals because they're testing the market. If they're going to a pitch competition one day and they're thinking, wait a minute, I need to make sure this is buttoned up and filed before the pitch. We want to see the filing before the pitch competition. On the same side of things, though, we see startups learn from their mistakes or learn as they're marketing a product. So it's not unusual to see multiple provisional applications. That shouldn't be a cause for concern.
Okay.
It's a good thing as long as they all get wrapped up into the non-provisional. We have a year from the date of filing for the first provisional to then file non-provisionally, and that priority date continues on with the non-provisional application.
So where does patent pending fall into that? What does patent pending mean when you see that?
It could be that a provisional is filed. It could mean that a design patent's filed. It could mean that a non-provisional is filed, as long as there's a filing. And a lot of times, any patent attorney is going to be able to tell what kind of filing was made based on the serial number. Some startups don't want to give up that. I tell some startups not to give that up, because we can tell a lot from what's going on with that number. I can usually tell when it was filed even.
Okay. And so what are some like red flags in a patent filing that an investor might need to be leery of?
If it was self-filed and it's very short, I mean, patent applications are long for a reason. I mean, even something as simple as like a planter for a plant. I mean, those can be long, detailed explanations of how water is getting out of that, the reservoir, and I mean, all these things get put in there. I mean, it can be pages and pages to describe, but inventors don't always think that way. They think, okay, I've said it's got a base. I don't need to say much more about that.
So I want to move on to trademarks and talk about trademarks for a little while. So how important are trademarks in early stage startups, and when should a startup start considering protecting their brand?
So I would say the patent process is going to be more important than anything else. Because not only do we have that time frame for filing the provisional into a non-provisional, if something's been disclosed, like through that pitch competition, then the time's running then to file within a year of public disclosure, or not public disclosure through a confidentiality agreement. We want that buttoned all up. Trademarks are important with establishing like that brand recognition. Some things in businesses, it lends themselves way more to that need to have that trademark. If you're doing a lifestyle clothing brand and you're manufacturing overseas, it's very beneficial to have that trademark pushed into the product itself in some way. Think about like how Lululemon puts their logo in the weirdest places, because their potential infringers also have to put it there. it's that sign of value there. But if we get the trademark registration early, then we can set this up with customs, and they'll block importation. That can be killer for an early brand because they're going to get knocked off so quickly. And that's always what the investor wants to avoid, seeing their money get down the pipe because,
no, that makes a lot of sense. So that's where we really see the value of a trademark come into play and how trademarks can actually increase the value of a company over time. So not always is a trademark necessary or increasing the value of an investment, but sometimes, depending on the product, we can see that.
Yes. And we want to see the business use the intellectual property in the right way, too.
Yeah.
So it's always that kind of discussion between counsel and the business owner, trying to make sure they're being proactive in what they can get asset-wise and how they're using it.
Yeah. So now I want to move and talk a little bit about copyrights.
Yep.
So we talked about you're not the biggest fan of copyrights. So tell me why, and tell me where copyrights maybe do have value and maybe where they don't.
There are some businesses that are great for copyright. Advertising businesses that are generating things that they don't want someone copying. The problem with copyrights is they are the least expensive of the property rights. I mean, provisional filing fees are about comparable to a copyright filing fee, but copyright applications aren't examined in the same way that a lot of people think they are.
Okay.
Patents and trademarks, we look and see what else is out there. Is this new? Is somebody else using this as a trademark? And so they're actually examined substantively. With copyright, there's no looking at the material being supplied except to make sure it's still copyrightable subject matter. And is the form filled out, maybe not incorrectly? I mean, they're checking to make sure it's done right, but it could still be wrong if you're not naming the right people in it.
Yeah.
Because the Copyright Office doesn't know. They can't check all of that.
Yeah.
So sometimes there's inherent flaws still in the property right, and when people get them, they tend to think that they've gotten something more than what they have.
Oh, okay.
So copyright can't protect someone else doing a podcast on investor concerns for intellectual property. That's still fair game.
Yeah.
But a lot of people think that that's, once they get that, then nobody else can do X, Y, and Z, and that can lead some businesses down this very nasty rabbit hole of trying to stop infringers.
Or thinking you have a UVP when in reality maybe you don't have a UVP, anybody can do what you're doing. So this false sense of kind of barriers to competition type thing.
Correct.
That makes a lot of sense. So where do trade secrets come into all of this? Where does that come into play?
Also considered some of the intellectual property things. Trade secrets come in when we have something that is truly going to be secret.
Okay.
A lot of my inventors start going that direction when we talk about patents, okay?
Yeah.
That's good. They think that maybe they can keep it a secret, they don't have to spend the money. That doesn't work if it's going out into the world.
Yeah.
If it's Coca-Cola and it can't be reverse engineered no matter how much Pepsi tries or any other soda brand tries, then maybe we got something that could actually be considered secret. But then we have to go through all the hoops of keeping it secret. And that's a state-by-state sort of determination. Most states have the federal framework for trade secrets, but we still look at little oddities there. Most of ours, we see them in the food industry. This makes a lot of sense. I mean, food's one of those things that trade secrets deals so well with. But when you think about those food manufacturers that we have in our state, they've got lockdown provisions. They've got contracts that say everything's confidential, that have exit interviews, reminding people, you cannot talk about this, you signed something. And it's, to some extent, over the top, but we have to be. It has to stay a secret, or the property right's gone.
So now I want to transition to just like IP as a whole. So how important is it that the startup entity itself owns the IP versus the founder, the university lab that it came out of, et cetera, et cetera?
University, I mean, that's a interesting little dynamic, because I mean, how do you get it into the startup?
Yeah.
I mean, I would say the entity that an investor is putting money in is the one that needs to have the intellectual property, or it needs to have the rights that can't be taken away from it. That's the key thing. We're essentially putting money into that competitive advantage that the business has. If the license right can go away, if the founder goes away, that's a problem. Or if the founder walks off with intellectual property, also a problem. We want to make sure the money is going to be tied in ways to that intellectual property.
So either the entity owning it, or some type of licensing agreement between whatever entity where, you know, we feel like we've got a good control. So what are you looking for in those licensing agreements to ensure that there's perpetuity, or that you're not going to put your money in, the licensing agreement goes away? What do those look like, and what are we looking for there?
I look at how long the term is going to be on that license. How easy is it for the licensor to break it? How are we going to be able to renew it? What's going on there? I'd like to see the license agreement. Sometimes those license agreements, especially sometimes the founders, have them with the entity itself, because they want to keep the intellectual property. They don't want to be forced out. And so that still works to a certain extent. They're still getting money, as long as the license agreement is of the right type that we want to see. If the founder has written it themselves and it's thin, then we might have problems. But if they're a robust license agreement, then it could be still beneficial to the investor.
So what are some simple questions or ways that investors can kind of figure out who owns the IP and feel good about whether or not the startup entity itself has the intellectual property?
With the property rights. When the patent's pending, sometimes we can still see that if it's been a published application. But non-provisionals aren't always published. Provisionals aren't at all, so we can't see those property rights. So the assignments and things like that, it's just, we would have to ask for them. And we need, if they're seriously considering an investment, then the investors should be able to see at that point the patent applications, the assignments, all the declarations, the whole patent, we call it the file wrapper. We should be able to see that and vet it out and see what's going on. Trademarks are, I mean, we do, those are published. I mean, as soon as something's filed, even if it hasn't been granted, if I filed something today, it's visible tomorrow. And so seeing that record, and investors should look there, because if the startup has taken any debt, sometimes the banks will go and also file liens or security interest against the trademarks and patents at the Patent and Trademark Office. And all of that's visible in the record.
Interesting. So kind of down that lane, What are risks or what can go wrong with IP that would put an investor at risk?
Put an investor at risk? I mean, if it doesn't issue, that's one big thing.
Okay.
The main one to me is always going to be, can the investor get back out of the business what they're putting into the business? And if the intellectual property isn't going to issue or register, I mean, then we're going to have problems.
So kind of adding on to that, what kind of risk do investors have if for some reason the IP isn't 100% truthful, or the filing isn't 100% correct? Do they bear any risk for that?
So it comes back again to, is the intellectual property going to issue or register, or is it defensible? So with patents, we have that mystery of the whole system. And so the patent attorney should be the one guiding and making sure everything's dealt right. But we see with some founders, when they're especially doing it on their own, they think, oh, okay, everyone's an inventor. All the founders are inventors. That's not accurate. And that can punch holes in the validity, potentially, of the patent. We also can see sometimes founders are like, okay, I submitted one thing, the application, completely forgetting that we also have the obligation to keep telling the patent office, or they may not even know, that we've got to tell the patent office what we know about. And then that bites the company in the butt later if they're trying to enforce the patent.
Okay.
With trademarks, we have this new real big concern of discount trademark filings. I have some clients that have come in and they're like, yeah, I paid $35 and then the filing fee, and then someone filed it like 4 weeks later. Like, okay, there's the date issue, but some of those too, they're kind of trademark mills, for lack of a better term. And the trademark office is starting to realize these are fraudulent. They had misrepresentations at the beginning for certain things. They may have said it was in use and created an AI specimen. All of that is leading to, right now, a purging of the trademark system.
Oh, wow.
So they killed a lot of trademarks since the beginning of the year, and there's current sessions going on at the trademark office to alert people of like what happens if this file now lands on your desk as a legitimate attorney. What do you do? And the solution is you kill that application and you refile, because there is no saving a fraudulent filing.
Wow. So following up on kind of legal risk and risk overall, now you invest in a startup, later on down the road, it's time for an exit or an acquisition, something like that. Can having fraudulent IP or incorrect IP or holes in your IP be a risk down the road for acquisition, mergers, or exits of some kind? And have you seen that happen?
I haven't seen it happen in killing the deal. I do know that there's reps and warranties and deals. And going through from the startup position, it's always making sure they're aware that they are representing that this is true and accurate, that they didn't do something that's going to be a problem, because the investors almost always can go back and get that money back from the founder if there's something that comes up later.
I want to wrap up and just kind of talking about what are the most common mistakes that you see early stage founders make when it comes to IP?
Not filing early enough, letting their pitch competition, whatever they're doing, their public sale, and then realizing 2-5 years down the way, going, oh, well, I want to protect that. And there's not a lot of protecting that in the patent space after that. And it can be detrimental to the business. I mean, that's when the competitors start really rolling in. And another big one, especially with the trade secret kind of situation, is not having their employees sign all the documents that they need to sign. And so if an employee that's key for the business can walk away and compete because they haven't signed anything, that's not only is it destroying the competitive advantage, some founders cannot get past that.
Yeah, yeah. Well, I appreciate you being here today and kind of lifting the veil on IP for us and giving us an intro into what it looks like and how we can kind of vet deals before they come to us.
Thanks for having me.